I'm the director of the Bureau of Consumer Protection at the Federal Trade Commission. First, my disclaimer, I speak only for myself, not for the commission or for any individual commissioner. So glad to see so many people here looking bright-eyed. I'm a little sleepy myself. So I'm hoping that I don't know about keeping you awake. I'm hoping I can keep myself awake, though. So I wanted to tell you a little bit about who we are and what we do and how we do what we do, and then talk with you about some of our priorities with respect to fintech. So the FTC, some of you, maybe all of you know this, the FTC has two missions, the consumer protection mission and also antitrust. So antitrust lives in the Bureau of Competition at the FTC. Consumer protection lives in the Bureau of Consumer Protection, which is me. I'm the director of that. We have 8 regional offices and 8 divisions, and I'll tell you a little bit about what each of the divisions do. We're about 450 full-time equivalent employees. We have probably another 100, 150 people throughout the agency who also support us. So think, HR, general counsel, facilities, stuff like that. But 450 sort of boots on the ground actually doing the work of protecting consumers. We have a budget of about $170 million. That's just for BCP, for the Bureau of Consumer Protection. So that sounds big, but in federal agency land, it's actually quite small. So if the CFPB is fully funded, that's probably about a $600 million agency. OCC is a $1 billion agency, I think, give or take. And those agencies both have relatively defined jurisdictions. So OCC, of course, oversees national banks, but nobody else. We oversee the whole economy. And in fact, though, let me tell you a little bit about our jurisdiction. We are charged primarily with enforcing the FTC Act. That's our organic statute, and it charges us with prohibiting unfair and deceptive practices in commerce. And we have, under the FTC Act, we have jurisdiction over the whole world except for banks. We also don't have jurisdiction over securities firms. That's just out of a matter of comity with the SEC. We tend not to enforce our laws against investment advisors and broker-dealers. And we also don't have jurisdiction, for the most part, over insurance companies. Regulation of insurance, as you all probably know, is reserved to the states. But everybody else we have jurisdiction over. And that's a big world. So, think finance companies, mortgage companies and brokers, debt collectors, lead generators, payment processors, credit bureaus, data analytics companies. All of those companies fall within FTC jurisdiction. Let me tell you a little bit about the 8 divisions that I mentioned. We have 5, what I will refer to, for lack of a better term, as substantive verticals. So 5 divisions that focus on substance, and I'll tell you about those. And then we also have a division that focuses on litigation support, a division of consumer and business education, and a division that focuses on consumer complaints and administering redress programs and the like, which all perform support for these 5 verticals. Verticals are a useful way for me to explain to you how we do what we do. As a management matter, I'm not crazy about it because that tends to make me think in silos, and we're not really siloed in that way. There's a lot of cross-pollination, as you'll see, between the different divisions. So the first vertical is advertising, and there we're very focused, I should say with respect to all of these verticals, we're very focused on technology and the internet. On the competition side of the house, a couple of weeks ago, they announced a new technology task force, which, with a great deal of fanfare, and I think, justifiably, that it was, something new to look at, particularly tech platforms and their effect on competition, something that the agency hadn't really done before. That, of course, prompted the question, though, what is BCP? What's the Bureau of Consumer Protection doing about tech? And the response was, tech pervades everything that we do. So everything that we do is focused on technology and the internet. So with respect to advertising, what does that mean? A lot of focus on online advertising, a lot of focus on influencers and social media, on ratings and reviews, which are an increasingly important way for consumers to shop. So you'll see that we've brought our first cases recently against companies that are purchasing fake reviews. We also brought cases within the last 2 or 3 weeks enforcing for the first time the Consumer Review Fairness Act, which is a new federal law which prohibits gag clauses in consumer contracts. Prohibits you from including a provision in your contract that would suppress truthful but unfavorable reviews and ratings. So second vertical is marketing, and that's where our do not call and robocalling and payment processing programs live. The third is privacy. So of course we have privacy and data security. We've brought more than 100 privacy and data security cases over the last several years. That's also, though, where our Children's Online Privacy Protection Program lives. We are the agency that is charged with enforcing and administering COPPA. So that's Children's Online Privacy Protection Act. And that's also where Fair Credit Reporting Act lives. Our enforcement division is responsible for enforcing all of our existing orders against companies, tech and otherwise. So you may have seen in the press that the FTC, this is public information, the FTC is investigating Facebook. And there have been a variety of press reports about what the outcome of that investigation might be. Some big numbers being thrown around about civil penalties. Suffice to say, that's a very important case for the Commission, and it is our Division of Enforcement that's handling it. Because what we're doing is we are enforcing an existing order that we already have against Facebook. We're now in the process of enforcing it against them. It involves issues around Cambridge Analytica and some of the other, widely reported alleged misdeeds of Facebook. So that's our enforcement division. And then last but not least, particularly for this crowd, is our financial practices division. There, it's a lot of online lending, a lot of fintech, a lot of debt relief, and that's also where our lead generation program lives. So that leads me to fintech. A little note about me. As some of you know, I see some friendly faces in the audience, and as some of you know, before I joined the FTC 1 year ago, I spent 20 years more or less in law firms as a financial services lawyer. So representing financial institutions, representing trade associations for financial institutions. So the term fintech has always been a little bit annoying to me because I have always thought that financial services is technology. And technology is financial services. So you think about ATMs and credit card processing and remote deposit capture. I mean, this is old technology that was innovated by financial institutions and by the Federal Reserve Board and by trade associations like NACHA. So fintech is kind of a misnomer to me, but I frequently we speak a lot about fintech. We hear a lot about fintech. So, fintech probably means very different things to each of you in the audience. It used to be that fintech meant cryptocurrency and payments, or fintech means, AI or big data. For me, fintech means, I brought a prop along, means offering financial services to consumers and to small businesses using this device, and all the stuff that goes along with that. So when I think about fintech, I think about the life cycle of a consumer financial product offered over a mobile device. And whether that's marketing, origination, servicing, collections, and that's the way we think about our enforcement as well in this area. And you might have noticed that I mentioned small businesses. So unlike other agencies that may be cabined in their jurisdiction to products and services that are offered for a consumer, family, or household purpose, we're not. We prohibit any unfair and deceptive practice in commerce, including those that are injuring small businesses. So just last week, we had a workshop on small business finance. And we call it small business finance because those of you who are in the business know that not all of these small business financial products are loans, that they're also, it's merchant cash advance, which is a type of factoring, which if structured properly, shouldn't be considered to be a loan. We don't really care about whether it's a loan or not. I mean, it might matter from the perspective of, say, whether or not the Equal Credit Opportunity Act applies. But certainly you can engage in unfair and deceptive practices with respect to an MCA as easily or maybe more easily than a traditional loan. So this is an area that we're looking at a lot, and we have traditionally brought cases to vindicate the rights of small business. So within the last year, we had a sweep where, working with our state partners, we brought dozens of cases that were against companies that victimized small businesses. For example, an update on the old Yellow Pages scam. A scammer would call a small business and say, unless you pay me $800, you're going to get delisted from Google. Well, that doesn't happen. But it used to be 10 years ago, it was Yellow Pages. Today it's Google. It's still a scam. We bring cases to redress that, even though it's not a consumer, right? It's a business. It's not a personal, family, household transaction. So we have no problem bringing cases against people who scam small businesses in other contexts, and we don't have any problem doing it in the financial context either. And it's something that we are looking at very carefully. So we believe strongly in the promise of fintech to expand access to credit, to reduce the cost of credit, to create products that are faster and more convenient for consumers. I mean, it is really remarkable that I could go online and borrow $10,000 this afternoon and have it funded to my bank account tomorrow. It's remarkable. And it's like, it's powered by credit bureaus and data and analytics and faster origination and new servicing mechanisms and new ways of marketing loans, and we believe that all of that is important, and we want to protect that innovation, but we also want to protect consumers. So how do we do that? So let's talk a little bit about marketing and advertising and some of our priorities in that area. We brought a case a couple of months ago against SoFi, who you all probably know. It's a student loan consolidator, and it's a good product. I mean, we didn't say that SoFi is not a good company and a good product. Consumers do save a lot of money by consolidating their loans, student loans with SoFi. They just don't save nearly as much as SoFi promised in its advertising. So SoFi had what we would call a deceptive door opener. It was a banner ad that popped up and said, people who refinance with us will save $17,000 over the life of their loan. That was one. The second was people who refinance with us will save $300 a month. Well, what happened was that SoFi, when calculating the lifetime savings, excluded people who refinanced into the same or a longer term loan. So you have, student loans, as I recall, are 10-year products frequently, and maybe you've paid down a bit of it and you have 8 years left to go, and you refinance into a 20-year loan. Well, you're going to save because you can't afford the monthly payments. Your monthly payment is going to be reduced hugely, dramatically, but over the life of that loan, you're going to be paying a lot more money. So what SoFi would do is they would cut out those longer-term refinances. And in fact, if they included everybody, all SoFi customers, in that calculation, they wouldn't have saved $17,000. They would have saved, on average, something like $5,000. Big difference. Still a good product, but a deceptive door opener, we think. we alleged. With respect to the monthly savings, SoFi did precisely the flip side. They would cut out of the population people who refinanced into the same or a shorter term loan. So you refinance into a shorter term loan, you're going to pay less over time, but your monthly payment's going to go up. So rather than $300, the savings was like $129 or something like that. So again, pretty gross overstatement if you actually look at SoFi customers. And it's the kind of thing that we're applying very old and sort of tried and true standards, advertising law standards, to what just happens to be a new product offered through a new channel. Lead generation is also an area that matters a lot to us. I think that my colleague Sandy Brown was on an earlier panel, and Sandy talked about lead generation. We brought a case against company Army.com. Actually, the company's name was Sunkey Publishing. It was a publisher, and it owned the Army.com domain name, which Army was just wasn't quick enough on the uptake and didn't buy Army.com. They own all the other ones. They own Marines and Navy and Air Force. They don't own Army. And it's an incredibly valuable mark. And these guys would they were Army.com, and it looked like an Army website. It had people in uniforms and talked about the value of military service. And when consumers would go and they would provide information, sort of a full-form lead, in order to be contacted by a military recruiter. When the contact came, it wasn't a military recruiter. It was a representative of Sunkey Publishing or someone who bought that lead from Sunkey. And they would say, yeah, the Army's not really hiring now, but so I feel, some of you may have heard this, some of you in the audience may have heard this story before, because I tell it a lot, and I feel like I'm exaggerating it, but actually I don't think I am, because what they would say is, there aren't a lot of opportunities with the military right now, but the military really thinks it's important, thinks education is important, and so we think that these are schools that that the military likes, and that you might be well served by pursuing a course of study at one of these schools. Do I have your permission to have them call you? So it was EDU, right? It wasn't the Army at all. I know this is primarily a financial crowd, at least I think it is. But it's the same difference. I mean, it could be you're generating that lead under false pretenses. So we held Army.com liable for that, and we took away their most valuable asset was the Army.com mark, which the domain name, which we took and gave it to the Army, who can now use it. But then. This is the interesting part. So this isn't new, a case against a publisher for generating leads under false pretenses. It might be Army.com. It might be, the illusory $100 gift card offer. It might be fake news websites. We used to see a lot of that, particularly for dietary supplements. Just completely fake news. One of the cases that we brought recently was it purported to be CNN and Stephen Hawking talking about how Garcinia Cambogia made him smarter. That's how he got to be so smart. We've seen the bad traffic and the bad leads. We know that it exists. We also know that good leads exist. When I say we, I mean all of us, all of you, and me too. But here's what we're doing now that might be a little bit different, is that we're not just looking at the people who generate that bad traffic, but looking at the people who purchase that bad traffic. In other words, the lead generators and the advertisers. And you're going to see cases more frequently against advertisers in particular. I think that I understand the challenges of vendor management, being a financial services lawyer. And that's what we're talking about. This is primarily a vendor management challenge. You're buying leads from people who you may not know and from people with whom you probably don't have any privity of contract. But you do have a relationship with the lead aggregator. and who gives you access to that network of affiliates and publishers. And what we're talking about is monitoring that traffic so you know where it's coming from. Because one of the things that is sort of vexing to me is that when we have been in investigations of these companies or in settlement negotiations, they say, well, you know, if this was really bad traffic, it wouldn't convert. But one of the things that we're seeing through sort of empirical evidence and analysis is that bad traffic frequently does convert. And I mean, it cannot be the right answer that it's okay for a brand to be buying this bad traffic and essentially funding this ecosystem of deception on the internet. And that's something that matters a great deal to us. And we have brought some of those cases in the past, and I think that you will see more of those cases in the future. I also want to talk a little bit about payments. So again, we're back to the life cycle of the loan, right? The marketing, the origination, the payments. Another provision that we care about a lot is the compulsory use prohibition in the Electronic Funds Transfer Act. So hopefully many of you know what I'm talking about. EFTA prohibits you from conditioning the extension of a loan on a consumer's agreement to have his or her account auto-debited. So bank deposit account, auto-ACH'd. Recurring ACHs, you cannot condition a loan on an agreement for recurring ACHs. So we've brought several cases against lenders, online lenders that have done that. So it's not a uniquely online issue, but it is a predominantly online issue because online loans fund electronically and are serviced electronically. And getting that authorization for the recurring ACH is critically important, particularly in the subprime space. So these loans are much more easily collected because what you're essentially doing is removing the consumer's sovereignty to pay to decide which bills to pay first. So the consumer who's in the non-prime space, who may be sort of struggling to make ends meet, and she has the utility bill and the rent and the car payment and the payment from for her personal loan, and she decides which one is she going to pay, and how quickly is she going to pay it, and who's going to get paid first. So when you have this recurring ACH authorization, it removes the consumer's choice in that respect. And more to the point, it's against the law. EFTA and Reg E prohibit it. We brought cases years ago against online lenders who just simply paid no attention to that. In the registration flow, it was, right above the signature line, you agree to have your account debited. Well, that's not legal. You're conditioning the extension of the loan on the recurring ACH. More recently, we brought a case against Avant. And what Avant did was in the registration flow, Avant had two little radio buttons. One said, I agree to have my account ACH'd. I agree to recurring ACHs. The second said, I agree to recurring RCCs, remotely created checks. From the consumer's perspective, that's a distinction or that a difference. What it means is my account is going to be automatically debited, and I'm not going to have any say in it except to either stop payment or somehow figure out how to revoke my authorization. And we said because Avant was an online lender, and because as an online lender Avant had to pick up the telephone in order to sell its products, we alleged that Avant was a telemarketer, and telemarketers are prohibited under the telemarketing sales rule from using remotely created checks, period, full stop. So that's our case with respect to Avant. I expect that there are more lenders that are using sort of purloining the authorization for recurring ACHs in the loan process one way or another. Another thing that I've heard about, we haven't brought a case in the area, is the lender says, okay, if you want this loan to fund electronically, you're going to agree to have it repaid electronically. If you don't want to do that, then we'll fund you by paper. You'll get a check in 7 days. I think that's a troubling practice to me. Again, it's not one where we have brought a case, but it's one that anecdotally I have seen in the marketplace. One final note before I close is loan servicing. So in the fintech space, I think there's a lot of focus on the front end of the platform, on the marketing, on the origination, on the AI and the decision science, and getting the underwriting cut correct. Let's focus on the back end, the loan servicing. And we saw that in the Avant case, and to a lesser extent in our case against our ongoing litigation against Lending Club. What we saw are sort of garden variety servicing issues. Loans, payments that are being debited more than once. Bad loan payoff information, then the consumer pays it off and she hasn't paid off the loan in full, and she gets debited again and gets late fees and the like. We saw failing to post payments is another issue, failing to post payments in a timely way, particularly paper payments, check payments. So these are all issues that we've seen in some of our cases. These rules are rules that brick and mortar lenders are familiar with, and online lenders and fintech lenders need to be familiar with them too. So with that, on that cheery note, I'm going to thank Performline for having me here, and thank all of you for indulging me. Thanks very much.